Welcome to New Possibilities. Today I have a special guest, Wyndal Gordon. He's a distinguished attorney here in Baltimore, Maryland. I'm glad that he's able to join us. He's a graduate of Morgan State University and the University of Baltimore School of Law. He's admitted to practice law in Maryland, D.C., and Virginia. He's a respected trial attorney here in Baltimore. He has a solo practice. He's a great legal commentator. He's appeared on programs like CNN, True TV, Headline News, and he's also the past president of the Monumental City Bar Association, and he's the recipient of numerous awards. And again, I just want to thank you for coming to this program. This is a little YouTube channel I have here. I talk about politics and issues of race. And I really appreciate you taking time out of your busy schedule to talk to me about this important case. And that's the Freddie Gray case. So I'm just going to start off by just giving some basic information about the case. Um, so we have Freddie Gray. He's a young African American male who was stopped by the police. He was stopped and he was arrested. He was put into a police transport vehicle. He was not belted in. He ended up breaking his neck and severing his spine. And a week later, after sustaining those injuries, and after being in a coma for a week, he ended up passing away. And the prosecution has brought charges against 6 officers who were involved in his killing. The first case went to trial and it recently ended in a mistrial. The first officer, who was the passenger in the transport vehicle, was charged with involuntary manslaughter, second-degree assault, reckless endangerment, and misconduct in office. And the jury, after deliberating for 2 days, they were unable to reach a verdict in the case. And the reason why he was charged is, they found that he was criminally negligent. This is the prosecutor. They said that he was criminally negligent for failing to secure Freddie Gray in a seatbelt, and they said that he failed to contact or to provide medical assistance for Freddie Gray when Freddie Gray said that he cannot breathe. So here we have a young African American man who's dead. And the city, in response to this horrific incident, was on edge. There were protests here and there was a rebellion in the city. So, as I said before, there was a mistrial. So I just wanted to get your assessment of the case. Like, first of all, explain what a mistrial is and where do we go from here, and just in general.
Sure, sure. Well, first of all, thank you for allowing me to be on New Possibilities. It's an honor and a privilege to be on your internet show. And just to correct just one or two things, I am licensed to practice law in Maryland and D.C. Federal, Maryland Federal, D.C. Federal. I'm not licensed in Virginia.
Okay.
However, be that as it may, and the Greg Porter, yeah, uh, it was a very interesting trial. My assessment of a mistrial, basically a mistrial is when a jury cannot unanimously agree. That is, all 12 members of the jury must agree beyond a reasonable doubt before can be convicted of anything they're being charged with. If they cannot agree, if it's 11 to 1, 10 to 2, 9 to 3, whatever that breakdown or that split may be, they cannot convict. That is not enough to land a conviction. So in this particular case, the jury hung. They could not agree unanimously as to any of the charges, which means that the state, I guess, well, not even I guess, they could not prove their case beyond reasonable doubt. Doesn't mean that they can't. It means that with and how they view the evidence, they could not agree on any of the charges. So the state's options are two things. They can either, well, two things. They can either dismiss the charges or they can retry the case until they get a verdict or until the defendant is acquitted. And that's what's going on in this particular case. So where they go next, I think is as good a guess as anyone. But if we look at the history of Marilyn Mosby, and I can't remember this case that was recently tried. Maybe as soon as she took office, it was a guy who was accused of murdering this college-bound teenager. Her body ended up in a river somewhere. Well,
Right.
that guy, the first case ended up in a mistrial. She retried it. I think the second case, uh, she got a conviction. It went up to the Court of Appeals, or no, the judge reconsidered his position and ordered a new trial. She retried it, and so that tenacity that she has, and in fact, she was going to continuously try this case until the judge threw her case out. I mean, that's how tenacious she was. So I expect that same tenacity with regard to the Greg Porter case. I don't see her throwing her hands up and saying, look, I tried and that's the best I can do. I see her retrying the case. Now, what's at stake? Taxpayer dollars.
Hmm.
Taxpayer dollars are at stake because it costs money to try cases. A lot of anxiety to the defendant. The roadmap has sort of been laid with regard to the terrain. We know what everybody's going to say. Everybody's committed under oath to their testimony. So you won't see many changes on behalf of the state side. But as you go try other cases, defense testimony or defense witnesses who may not have appeared in the first case and who may appear in the subsequent cases, they have wide latitude to sort of develop their own testimony in light of what's already come out already. So basically, they can kind of build their testimony around what the state has proffered thus far. So it's going to be an interesting set of subsequent trials. Whether or not Greg Porter is tried, right at whether or not he's going to be the next trial is up in the air, or whether or not he's going to be pushed to the back and the other cases go forward and they just retry him in the
Yeah,
back.
because they mentioned that they wanted to use his testimony in the case against the actual driver, officer. What's his name? Goodman or something like
Carson,
that. Yeah, right.
see,
They wanted to use his testimony in that case. So they were talking about like
that's a
postponing
plus.
in the second trial, and what are your thoughts on that? Like, the
Well, there
idea.
are a lot of things. Yeah, that's a great question. There are a lot of things that go into that because these guys were indicted and they've been arraigned. Somebody has a right to a speedy trial
Right.
to be tried within 180 days of their first appearance or appearance of counsel in court. So if these does not find good cause to postpone the subsequent cases merely because she ended up in a mistrial in her first case, which to me, in my opinion, that is not good cause to extend those other defendants waiting to go to trial, that she may be kind of stuck. And in terms of using Porter's testimony against some of the subsequent defendants, well, Porter, there's no reason for him to assist the government at this point. They have no leverage. A mistrial in the Porter case is almost as good as an acquittal. It is not as good as an acquittal, but it's almost as good because the state doesn't have any leverage to force you to do anything.
Right.
And quite frankly, a defense lawyer would probably feel a bit emboldened by the fact that there was a mistrial. And he's probably digging in his heels, whereby probably not willing to take anything that involves a conviction. He may be able to submit to probation before judgment, which in Maryland is not a conviction. It's basically a finding that if you successfully complete the court's probation after 3 years, you can get it expunged from your record. And basically, it's not a conviction. It's not an acquittal. It's just basically probation, and it just gives you a second chance. And if anybody ever asks you whether or not you were convicted with probation before judgment, you can still tell them no. That's the only thing that I would accept if I was representing Greg Porter. Other than that, I'd probably retry the case, depending on what that split was.
Yeah,
And
that's what I
nobody,
want to know. Like, they haven't talked. The jurors have not made any statements to the media. We don't know, like, if there were a majority for conviction or against conviction. We don't know, like, the racial breakdown in terms of how this case ended up being a mistrial. So, what do you think? I mean, do you think that they had a weak case? What do you think about the evidence that
well,
was presented?
I thought that the case was rather flimsy. The first day of trial, I sat in, the first day of testimony, and I listened to the testimony. And I heard what to me was reasonable doubt during that period of time. And my understanding is that it only went down, it only started to downward spiral from there. But what I did hear was that the state's attorney's office landed a great closing argument, and the defense attorney's office, their closing argument wasn't as strong. So maybe closing arguments had something with it, but I thought that it was going to be a flat out acquittal. And I thought for good reason. And so I don't know what the jury was grappling with, but whatever it is, we have to give kudos to them because they accepted in a very daunting challenge, and I think they did an awesome job. What I like about these particular jurors, is that they didn't relent. Whatever their convictions were with regard to the facts and the evidence of this case, they didn't relent. You know, they whatever they felt about it, whether they were for a conviction or acquittal, they made sure that they held out to the very end. And that's all you can ask from a jury, to make sure that when they make this decision, this is a decision that they're going to live with. They feel as though they've done the right thing. And if they can't agree as to one singular outcome, then let it hang and let the parties do it again. So much respect and hat tip to all the members of the Baltimore City jury who sat on the Greg Porter case.
So, what was it about what you heard that made you lean towards reasonable doubt?
Well, what I first heard was that they had this so-called policy that came out on the 9th of April, and it was wrapped up in a 90-page PDF that was not accessible to Officer Porter, at least from his testimony. And this incident, as you know, occurred on the 12th of April. So that's only 3 days later. And no one communicated to them in their command staff, or when they meet in the mornings, or however, or whenever they meet, that these new policies had come out. Now, this one policy dealing with seatbelting. Now, we all know that you should be seatbelted in any type of vehicle when you're transporting individuals. However, this one policy regarding seatbelt was buried in this 80-page email, and that policy made seatbelting mandatory, but they never communicated that to Porter. So I'm looking at that. I'm looking at some of the issues with
So, without
regard.
that, I just want to stop for 1 second. So, with respect to the seatbelting issue, the fact that they didn't, you're saying that they may not have communicated that information to
Right.
Porter and other officers. But what about, would that necessarily mean that the officer acted in a reasonable fashion by not buckling in a suspect?
Yeah, well, when you're dealing with this case it's a great negligence case. For instance, if they're just being charged with negligence, you fail to lock seatbelt your child, are you going to expect to be taken up in manslaughter charges if the child dies? I just don't know. Reckless endangerment, yeah, you have a colorable case for that, but manslaughter, and then to the extent that they're trying to allege it, you have to at least have some, and then you have police officers have wide latitude and discretion. But when there's a policy in place, you expect police officers to follow their policy. If there's no policy, then they're subject to using their own discretion. And for whatever reason, and he made some flimsy argument, but it was an argument nonetheless, that if he had gotten too close to Freddie Gray, he could have gone after his gun or something. Any old thing would do. And not saying that that's something to be believable, but that's at least something that the jury would consider and will prevent the case from being knocked down on a motion for judgment of acquittal. So the fact that the case went to the jury um, means that there was sufficient evidence there to allow the jury to decide, and it wasn't something that could have been knocked out on an issue of law. So yeah, I do believe that that issue deals with is bears greatly on reasonable doubt, because it is a policy that's in place, that if you have these new policies in place, and if the failure to um, comply with those policies could lead to not only termination but criminal conviction, yeah, I think that you would have a duty to notify those persons who are subject to that policy about this policy, and not just let it happen through osmosis. I think people need to be well informed of their rights and
Okay.
duties with regard to these
And what about
policies
the issue of like the medical attention? Like, from, some of the information that I read, Freddie Gray said that he could not breathe and that he needed medical attention. And apparently they failed to provide that medical attention within a reasonable time period after he told him that he needed it. So that's
implement.
an issue as well that determines whether or not Porter is guilty of reckless endangerment and these other charges as well. So, what is your assessment of that aspect of the case?
It's interesting that you bring that up, because I was just researching a similar issue in one of my 1983 civil rights types of cases. And what I read through the case law was that as long as an officer makes an attempt, or attempts to try, attempts to provide medical assistance, that is the extent of their duty. And so where there's a complete failure, then you may have some 1983 liability, and that's just on the civil side. But when there's an attempt, you can't even get it civilly. So, the civil standard is a much lower standard than beyond reasonable doubt, which is way up here. Civil is like somewhere in the middle, whereas isn't more likely than not. So if there is uh, testimony available, again, that he failed to provide this assistance or didn't, well, not that he failed to provide the assistance, but just did not provide the assistance in due time,
Right.
that's
That's
a
the
jury
issue.
question. That's a jury question. And so one juror might say, well, he knew him and he thought he was faking, and I just can't say that this was a material omission, or this is something that makes me feel on beyond reasonable doubt that he's guilty of these charges, as opposed to, maybe he was negligent. And another juror might say, well, I believe that he should have done it, and I believe that he's criminally responsible. And so these are the complexities of the cases that these jurors are grappling with, and that maybe it will be pretty difficult for 12 to agree under those circumstances. It's certainly reasonable to understand why they disagree.
Right. Okay.
So that's how. Mm-hmm.
Yeah, so also like I was reading about this case and they talked about like the ambiguity in terms of some of these charges. Like there's some vagueness in the law in terms of what constitutes involuntary manslaughter and the whole issue of depraved heart, having a depraved heart, especially in this case. So can you provide some insight on what are the elements of those crimes that need to be
Uh,
proved?
Basically, I think it's got to be conduct that is reckless and would make you reasonably believe that someone's at risk of death or serious bodily injury. But it's got to be extreme conduct. I can't remember the exact elements, and I wish I'd have known that one. I would have pulled that up. But in terms of just dealing with these concepts, just your interpretation or anyone's interpretation is reasonable. You know,
Mhm.
do you think it's reasonable or unreasonable to not belt in a prisoner in the back of a van? And people may disagree for whatever reason. You know what I mean? So it's just one of those things. So
So if
they have.
like in terms of this case, so what do you think is going to happen if it goes? You think it's going to be dismissed, or if there's a retrial, do you think that it's going to have the same result, or you know, an exoneration, or what? I mean, you kind of hinted to it in your comments in the beginning.
Well, put it this way: I think it'd be totally boss if Marilyn Mosby retries this case. And quite frankly, I don't know what other options she really has,
Right.
unless she can try the subsequent ones and obtain a conviction from there. But it would certainly show that she is really adamant about ridding the force of what she believes to be, bad officers. And so I don't know what her decision is going to be. Obviously, it's going to require some financial considerations as well as labor in this case. But I think she almost has to retry the case. But if she doesn't, I don't think there would be much of an outcry because she's got, as we all know, 5 more defendants to try.
So, what do you think about the other cases? You express your concerns about this case against Porter, but what about the other defendants? Do you think their case is on a similar level in terms of the strength of the case or weaknesses of the cases?
I think they're certainly on a similar trajectory in terms of the strengths and the weaknesses because the state, a lot was exposed throughout the Porter trial. I mean, there were weaknesses, you know, punched throughout that case. I think that this case was kind of mischarged in the very beginning. I think it had been charged a little differently, then the outcomes probably would be a little different. We're focused on what happened in the van, and it's my understanding we're focused on the van because the medical examiner was directed to this van.
That's a
But
good point. Yeah, that's a good point.
everybody can see. I mean, it's right there in the video that he was obviously hurt before he got into the
Yeah, I
van. Now,
wonder why isn't that being raised? Because like when they take him into the van, he's not even walking; he's dragging his
right,
feet, and he looks like he's in pain. But
right.
nobody's addressed that. Like that's not addressed in a medical report. I don't get it. So what do you think about that?
When the state locks in on a theory, a state can't have multiple theories as to how a crime is committed because that would create reasonable doubt from the very beginning. The state would lose credibility. I think that when the medical examiner's report came out, which was I guess fortified by some of the police investigations, they came to the conclusion that this injury occurred in the back of the van, as opposed to dealing with these officers in the yellow shirts who first had their hands on Freddie Gray, who I believe are very culpable or extremely culpable, and in fact guilty of what happened to Freddie Gray subsequently. Now, something could have happened in that van, and I'm not discounting or dismissing that. I believe that what occurred in the van is perhaps an exacerbation of a pre-existing injury that he sustained in the field with those officers in the yellow shirt who first handled him. And so, I feel like they should have focused on those officers, given them more attention as opposed to the ones in the van and the supervisors, because I think their level of culpability is minimal at best. I mean, even if you find that they failed to render assistance, basically you're going to make these individuals murderers because they failed to follow an office policy. And I
Yeah.
just don't think that's going to be enough. But if
Yeah, I
you
think
focus
only one of them is charged with murder. I think there's one person that's charged. I think that may be the driver, if I'm not
for the
mistaken.
manslaughter, when I say murder, I'm talking about
Oh,
manslaughter.
you included
I should have said,
manslaughter as well.
I should have said homicide,
Okay.
charged with homicide. So for failing to follow an office policy.
Hmm.
And I just don't think that anyone really is subject to being convicted for that. For misconduct in office, perhaps, but that's a very high standard. But what happened to this young man in the field? I
Right.
mean, we know he was hurt. We could see that on video. So, whatever was going on, even if it was a hairline fracture at that time, it could have become worse in the back of the van, and that doesn't make the person who's operating the van guilty of the crime.
Yeah, because if I'm not mistaken, they had him pinned down like on the ground, and
right,
perhaps there was some kind of injury to his back at that point, but we don't know.
you, you've seen many cases where these officers put their knee in the back of your
Right.
neck. You know what I mean? We've seen these cases in Freddie Gray. They'll put their knee on the side of your neck. They'll put their knee in your back so that you can't breathe. Compress. Restricting your breath from compressing your chest against the ground. They have all kinds of techniques that can cause serious injury to individuals. And if you apply any of those techniques wrong, you can cause an injury. And I just believe that they first injured his neck, and by the time he was in that van, he was in an unstable position or an unstable state where he could not take any more trauma, and he received even more trauma by being in the back of the van, just for purposes of by way of the van just traveling its normal route and hitting whatever bumps may be in the road. So I really and truly believe that those officers, and I hope to see at least those officers convicted of something. They've been charged with second-degree assault and I believe some other misconduct in office or something to that effect. But at least the second-degree assault, I would like to see those officers, that is the 2 or 3 who first handled Freddie Gray, because I believe all of this case is about what they did in the field. Everybody else are just sacrificial lambs
Yeah, that's
for these.
true because like they're the ones who chased him and arrested him, and from what I
And then,
understand, they didn't have probable cause to do so. I mean, he just looked at him, and based on that, they pursued him. So what do you think about that? Do you think that they had probable cause to arrest him to begin with, based on
well,
him
there,
looking at them and all that kind of stuff?
there's that cuts both ways, and that's going to actually be a jury question, because there's some testimony that came out that says that Freddie Gray was running anyway. He wasn't running from the police; they were already running for whatever reason, and the police started chasing him. Now, if he looked at him in a certain way and then took headlong flight in a neighborhood that's not that is what you call it a bad neighborhood, may be enough to give chase and maybe enough for reasonable suspicion. However, when they recovered the life, it wasn't as a result of reasonable suspicion. It was as a result of them searching him, going into his pockets to figure out what it was he had in his pockets. That's a probable cause search. So the flight alone is not necessarily probable cause. A flight alone is enough to, hey, stop this individual. But when you stop an individual, you don't have the right to search them throughout their body. All you can do is pat down their outer garments for weapons. And if you don't find anything, then that's all you can do. Now, when they patted down his outer garments, they didn't find a weapon. It wasn't until they went into his pockets and when they found the weapon. But when they go into his pockets, that's an illegal search right there. Now, is this weapon a legal knife or was it a switchblade? I mean, that's another question because there's a dichotomy out there that says that this weapon was a legal knife. Now, we all seen these knives that young people that they carry. You can buy them from the 7-Eleven, the convenience store, and these are legal knives. Believe it or not, no matter how dangerous they appear to be, they are legal knives.
Yeah,
And
they
the
sell those
switchblade,
everywhere in the city. Like you go to
yeah,
any gas station or any convenience store.
and some of those knives look extremely dangerous, but they're legal.
Yeah.
You know what I mean? And so long as it's not a dirk knife or a what they call a Bowie knife, and we've seen the dirk knife in those cases where you saw um, the ISIS folks severing folks' necks. Okay, that's a dirk knife, and the Bowie knife. We've seen that as well. Some of those knives look like the kinds that pirates used to carry. So so a switchblade, we all know what a switchblade is, a spring activated knife. And so if there was no spring activation on it, then this was, a legal knife that he was allowed to carry. And 9 times out of 10, I'm almost inclined to believe that this was nowhere near a spring activated knife or a switchblade because people don't carry those things anymore. They carry those little pocket knives that you get out of these local convenience stores. So if that knife constitutes a legal knife, then there was no probable cause to actually arrest him and take him down to the ground. At best, you could have stopped him, but to have your knee all in his back and all that stuff, puts him under arrest so that he would end up in the back of his paddy wagon. There's no probable cause to support that. And that's been the state's position since day one.
So you kind of touched on this before, but if you were the prosecutor, if you were in Mosby's position, how would you have pursued this case?
I would have focused on the gentleman in the white shirts because I believe that those were the ones who committed these injuries, or at least got the injury started. I believe that they were exacerbated in the back of the van. But how's the van driver supposed to know? He didn't even put the person in the back of the van. It was those officers in the yellow shirts who loaded them into the van. So, I mean, he's not a doctor, and he may have heard him, agonizing, but I just believe that even if he didn't take heed to his agonizing yelling and screaming, again, that's an office policy. I don't think that rises to the level of a criminal defense. I believe it's negligence. It could even be gross negligence, but I just don't believe it's a crime.
So you don't think it would be like a form of criminal negligence from your understanding?
From my personal professional interpretation of it, no. Now, reasonable minds will disagree because there'll be others out there who say, well, I think he should have done this, and everybody knows if you load somebody into a van, you gotta lock them in the seatbelt. But do we lock ourselves in the seatbelt when we put our children on these school buses every day, or when we get on what we call commercial transportation? Do we lock ourselves in the seatbelts? Maybe we do, maybe we don't. But if we don't, are we, contributory negligent? If the bus gets into an accident and we get hurt, or if our child gets hurt because he wasn't locked in the seatbelt on a common carrier, that's the question. And so those are issues for juries to consider. And again, it doesn't matter whether it's a Baltimore City jury or a jury in Wycomico County. These questions are going to remain. It's just going to be difficult, for people to unanimously agree. But I think it's still worth the shot of retrying the case.
Mm-hmm. Okay, and I just want to conclude with a couple of more questions. The first question is this: what kind of advice would you give to young people who encounter the police, like people who are in Freddie Gray's situation, for instance? If they have an encounter and they're stopped by the police, what would you advise them to do?
It's good that you asked me that because every time I go around and I speak on these issues, I use this right here. It's a smartphone, and all of us have these smartphones. And I always say that we have technology. We wear it on our hip. We keep it on as a part of our body now. It's like almost an appendage to our body. And anytime you're stopped by the police, you have the right to record video and audio. But on your smartphone, you have an audio recording device. So even if you're nervous about recording, doing a video recording, you can do an audio recording. And basically, you go to your smartphone, you practice it, and you press audio record, and you just record everything that's taking place. You can have it in your lap, you can put it in your pocket, you can put it anywhere, and you just record it. and so that you have some type of memorialization of the encounter. Now, this works two ways. If you're a young kid, you could take the recording home to your parents and say, and let them listen to it, and they can hear how you were treated by police and what you did wrong and what you did right. They can either compliment you on what you did right or kind of correct you on what you did now. And if something goes really wrong during the encounter, you have this piece of evidence that you can provide to somebody like me, and I can get it transcribed into a transcript of something that will be useful in court, or even just play it in court. And this is a very critical piece of evidence. Police officers have technology. They're wearing body cameras. They have technology in their automobiles, and you have it as well. So you're not powerless. And there's this smartphone will indeed protect you. So I would just say, make sure you use it. Use the audio recording device. If you're too nervous about using the video recording, you don't want to be shining the video in the officer's face. And what you do is, so that you don't make the officer suspicious, the minute you see the blue lights come on in your rear view mirror, you go get your cell phone and you hit record. Because a lot of times if you hit record during the middle of the stop, they're going to say that you didn't record the whole stop and you don't have all the information, everything transpired before the video recording came on. But if the blue lights are on and you're just in your car, you're like, oh man, find your cell phone, get it queued up, hit record. You can put it on your dashboard, put it in your pocket. You can put it anywhere. You know what I mean? Just make sure that it's on and that it's running. And a police officer would be none the wiser, because even if you have it on and you click out of it, it'll still be running. It's still running. Even if you go back to your regular screen, you'll just get a red line up at the top like that. And so record these things. Every single stop, you should record it. And trust me, I didn't learn this on my own. I had a client who did that for me, and he was able to give the recording to me, and he was pulled over for a busted tail light, and he ended up being charged with assault on police officer, failure to obey, disorderly conduct, and trying to disarm a police officer. And if it wasn't because of this recording that he had, he would have been looking at a lot of jail time. We ended up getting all the charges dismissed except the tail riding with the busted tail light, and that was just $55 fine. And so that's when I learned that, I was like, I'm going around every time I talk about this, I'm going to tell people to use not only the video recording device, but because people get nervous, and you have to act fast, so you have to practice using it at home. But once you should master it, and then when the lights come on, like, don't even wait till you actually pulled over. Just before you're pulled over, the minute they come on, you should know automatically to go pull your phone up and hit the record button. And so that's what I.
So what would you tell them in terms of their rights? Like when they're stopped by the police, what are their rights? Like what should they do if the police stop them and they ask them questions, or they want to search their vehicle or search their person?
Have this recording on first, because if nothing else, I want you to learn throughout this interview here is that you record everything. Now, when you stop, you have to produce your driver's license, your registration. The police have the right to ask you to get out of the car. They have the right to ask you to get in the car. You have the right to record a police officer in the performance of their public duties. You're out of the car or in the car. Now, I understand that might not be a right that you want to exercise conspicuously, and sometimes you have to do things inconspicuously. But still, when it comes to the end of it, at the end of the day, you have to protect yourself by using your recording device. Now, they're going to ask you for your driver's license, your registration. They may or may not tell you why you're stopping until they come back with the ticket book. Now, if they want to search your car and there's no reason for them to search your car, then you tell them that you don't consent to them searching your car. Make sure your video recording is on, so it's clear that you do not want them to search your car. Now, police tend to do because they think nobody's watching and nobody's recording, but you're different because you got your recorder on. And you tell them expressly and clearly, like, why are you searching my car? And complain about, why are you searching my car? I ask you not to search your car. And if they get belligerent with you, then just calm down. Let them do what they're going to do, because you know what? You already got something. You got their ticket because your recorder is going. So don't even worry about it. And the rest, you leave to your lawyers, and your lawyers will take care of it. But in terms of searching your car, even if you're nervous, you have to invoke your rights. You do not let a police officer search your car for any reason, even if you know you've got nothing in the car. If they're asking you if they can search your car, that means they don't have the right to search your car. Now, they may ask you in a forceful manner, "Oh, can I search your car?" You know what I mean? If you're not hiding anything, let me search your car. Don't even give in to that. You know, they're asking you to search your car. They don't have the right to do it. If they have the right to search your car, they're not going to ask you. They're just going to search it. So that's what you have going for you.
So
And
what if
even if
you're walking on the street, like you're walking on the
Mhm.
street and they stop you and they
Right,
want to frisk you and all that stuff?
right,
What are your
you do
rights?
not have you do not have a duty to speak to police in the mere accosting situation where they walk up to you and they want to ask you some questions. You should walk away from it. I tell people to treat police the same way you would treat a stray dog. And I know that's a little probably a little harsh these days, but you wouldn't necessarily go up to a stray you wouldn't necessarily go up to a stray dog and offer, whatever to a stray dog. You don't know if that dog's going to bite you or lick you, so you just stay away from it. And unfortunately, because of the way society is today, which is much different than how it was when you and I were young, the way society is today, you really have to approach them in that manner. Like you don't really go up to police unless you really need them. Don't start talking to them about things because you never know what their angle is. They've been doing something. They might be investigating something that you have nothing to do with, but they may think you do. They may think that you fit a description, so to speak, and they may ask you where you at such and such a place at such and such a time, and maybe you were there, and but you weren't the person involved in this particular activity. And so now that you were there, you placed yourself there by answering just a few questions from police. Now you're being charged with perhaps a robbery or some other offense. So you don't go around volunteering information to police. You don't talk to them. And whenever they want to speak with you, you demand to see your lawyer. I mean, that's first and foremost. You demand your lawyer and you invoke your rights to remain silent. There's no duty to speak to police under any circumstance.
Okay. Now I want to conclude by just asking you about protesters. Like I know that there are some protesters that have been saying, "Well, this is an outrage. This is like unjust. You know, this is a reflection that the system doesn't care about Black lives." What would you say to them in response to this mistrial? What would you tell them? Like,
Well, um, I can't. You really can't control the way people feel,
right,
and a lot of protesters are out there not solely because of the Freddie Gray trial. They're out there. The trial is something that ignites the feeling to to protest the injustice of the African American males or whatever the issues are, particularly in this particular case, African American males. It's not just about the trial. It's about police terror. It's about police brutality and excessive force and things of that nature. So the trial is going on, and I think we're being sort of short-sighted when we just say, they're just protesting the Freddie Gray trial. Now, that is a part of it, and perhaps even large measure, but it's not all of it. And so I think some of it, maybe modicum of it comes from just misunderstanding the process of what a mistrial actually means. But then a large part of it comes from just being fed up from the police terrorizing their neighborhood and oppressing their communities. And so the trial creates the perfect opportunity to again raise these issues and put them in the forefront. That notwithstanding the Freddie Gray or the William Porter trial, we have these issues out here that we're still talking about. And so more power to the protesters who have the gumption to be out there. And with regard to the trial, I think the trial is moving in the right direction. I think the cases are moving in the right direction because look, who else had the courage to prosecute police
exactly,
officers? Who else had the courage to do it? And now you see people jumping on board across the country, but before nobody was doing anything, and
that's
that was
true.
that was free. That was the cool thing to do. So we have to support Marilyn Mosby, and I disagree with some of her policies with regard to how harsh and heavy-handed she's been with the protesters. In fact, I've been representing a few, and they've come very heavy-handed. Luckily, the judges and the juries don't agree with their stance, and we've had an acquittal of one, and other one we had an acquittal of one of the most serious charges, and we received probation before judgment on the remaining charges. So the judges and the juries kind of understand these protesters, and the prosecutor's office is really trying to deal with them with a heavy hand. But I think at the end of the day, there is a balance and counterbalance where that will make everything okay. But protesters continue to do what you're doing. I mean, because the minute that you stop and become less vigilant, we'll have another Freddie Gray matter. So I think they're an important piece. Everybody has a role to play. That's their role. I appreciate them playing it. We have our roles as attorneys who have the ability to offer defense to those who find themselves ensnared in the system. And the community activists, preachers, teachers, everybody has a role to play. And if we all play our role, maybe we can reduce some of the issues that we're facing with regard to police brutality.
All right. So, one last question. So, you mentioned one of the protesters that you represented, um,
Mm-hmm.
and if I'm not mistaken, did you represent the gentleman who was accused of smashing a car window?
Yeah,
So, what kind of
that,
charges did he face? Like, what
well,
was the?
the biggest charge and that we're fighting for is the rioting charge, and they're dealing with him quite harshly. They want him to do like 8 years or something crazy, and it's going to force me to try the case. Now, quite frankly, it's going to be a challenge to try the case and end up successful. So I think I just need to try the case so the public can see where he was coming from, and understand that he is a human being and not some roving criminal. And maybe the judge will see that, and if something doesn't happen the way we would find satisfactory, the judge can be the equalizer and make things right. So, but they're coming after him. They're offering him years, and I'm like, I think that's completely ridiculous because the car was fully insured. It's probably $1,000 worth of damage, or just over $1,000 worth of damage. And that was a one-day incident, an aberration, and it didn't reoccur. And so, they turned a malicious destruction case, a rogue and vagabond, as they would call it, which are both misdemeanors in terms of what the damage was. And they turned it into this big rioting case where, as if this young man's responsible for all the rioting in Baltimore City, and rioting, as you probably don't know, carries a life sentence. And so you can get anywhere between 0 to life for rioting. And most people don't know it because it's a common law crime. So long as the sentence is not cruel and unusual, that could be the maximum penalty. So I don't see this as a life sentence either, but I don't even see it as something that's worthy of an 8 year, even a 4 year sentence. I'm just going to fight hard. You know what I mean? I'm just going to fight hard and do the best I can for this young man.
Yeah, well, I look forward to hearing more about that case, and perhaps we could have you back on, to talk about that
Yeah,
case
we'll talk
in
about
particular.
that.
I really appreciate you, you know, appearing on this program. I greatly
Pleasure.
appreciate it.
My
You've
pleasure.
really provided a lot of sound advice and commentary. And I just want you to let people know how they can reach out to you on social media and, other places as well.
You can find me almost anywhere: Facebook, Periscope, Skype, Instagram, all the social medias, YouTube. I have a YouTube channel, The Warrior Lawyer. The Warrior Lawyer. Facebook. If you can't remember my name, J. Wyndal Gordon, J. Period Wyndal, Wyndal Gordon, Gordon. Just plug in The Warrior Lawyer, and you can catch me anywhere.
All right. All right. Well, thanks again for appearing. I really appreciate it.